Sorry about dividing the video there, at a technical issue. Administrative Procedure Act, Federal Model State Administrative Procedure Act, State. These are detailed statutes regarding how administrative agencies must function when they are deciding cases or issuing regulations, the two basic tasks of administration. Trial type hearings. Proceedings happen inside of administrative agencies similar to they would in court. The case is tried before an administrative law judge, an ALJ. So if you're in trial court, which is like a regular Ohio Common Pleas Court, that would be your honor, your judge, trial court judge. Different terms in regards to how you would address or their official title would be for Montgomery County, Ohio, trial court level judge. Inside an administrative agency, the technical term for that trial level type of judge would be an administrative law judge. You would still speak to the judge in very respectful manner, just like you would inside of it. It would appear and everyone would act as if it was a similar type of etiquette occurring. So you would call the judge your honor, be very respectful, those types of things. Some of the things that are similar, the accused parties or the defendant is entitled to receive notice of the issues to be raised, to present evidence, to argue, to cross-examine, and to appear with their lawyers. Also, ex parte communications are allowed to occur, just like in trial court. What is ex parte communications? Ex parte being a Latin word, and what it means in regards to the legal setting is that the judge and the judge's staff and chambers are not to communicate to one side by itself. They're to communicate with both sides at the same time, so that both sides are getting the same information and things are fair. One side is not getting an advantage or a secret kind of side conversation that would then, of course, concern the other side that this is going on. Ex parte communications. Not allowed. It's not allowed in administrative law judge court. It's not allowed in any other court that I know of, especially in Ohio trial court, since I was using that as an earlier comparison. However, there is a burden of proof. You've likely heard that term before on TV shows, that type of thing. It's the burden of proof is the level of proof that the plaintiff, perhaps the defendant, might need to bring if they're bringing their own cross-action or cross-claim. But it's the amount of proof you need to prove your case, just as a generic way to describe it. Inside of an ALJ court, it is a lower standard and only requires that the party produce more persuasive evidence than the other side. The rule in most administrative proceedings is substantial evidence. Regarding an administrative law hearing, which of the following statements is false? The hearing proceeds in a similar manner, similar to a trial court hearing. That would be true. That's correct. I was just talking about that. The hearing will be tried before a jury. That is going to be false. That is typically not how it works. It's going to be a bench trial. It's called a bench trial because the judge sits behind a bench. Therefore, only the judge is residing as the jury, if you want to think about it that way, and would only be a judge decision, and there won't be a jury there. The hearing is presided over by an administrative law judge. That's true. We were just talking about that. And the accused company can defend itself through its lawyer. That's correct. We were talking about that. So the false answer there, which we had not mentioned previously, is that there won't be a jury present in an ALJ courtroom. So we have burden of proof being a little bit different and no jury being there. Otherwise, it's going to look the same, act the same as a traditional trial court. Scope of judicial review. So you can, as we were talking earlier, appeal out of the administrative law judge courtroom potentially, but you need to first exhaust your administrative remedies. Assume an administrative agent gives erroneous information to Jasper over the phone. Jasper follows the erroneous information. As a consequence, Jason is subject to an administrative fine under the doctrine of sovereign immunity. Overturning agency decisions. Agency actions that are ultra vires, beyond the scope of its authority, are set down in statute. Agency did not abide by its own procedures or those imposed upon it by an Administrative Procedure Act, or if there is virtually no evidence to support the administrative agency's findings, the court may reverse. So these are difficult levels to reach in order to get an overturning of an agency decision once you do get outside of that ALJ courtroom. In deciding an administrative law case upon appeal, the burden of proof that will be applied is... After Susan was laid off, she was denied unemployment compensation. She filed a claim with the Department of Job and Family Services and asked for a hearing. The administrative law judge ruled against her. If Susan wants to appeal the decision, she should what? Remember, we were speaking about appealing earlier there. Scope of judicial review. You need to exhaust your administrative remedies before you appeal. Rulemaking informal. So now we're getting into rulemaking. The APA, which is that administrative law. Let me see the APA. I am forgetting. Here, let's just jump right back up here. Sorry about that. The APA is the Administrative Procedure Act, the fundamental statute for detailing how the agencies must function, and their two basic functions, which are going to be, of course, promulgating rules or laws. Oh, whoops, too far. All right, rulemaking informal. So the APA directs that when they're rulemaking, they need to give notice in the Federal Register of their intent to do so. That's published daily. The notice must specify the time, place, and nature of the rulemaking and offer a description of the proposed rule or issues involved. Any interested persons or organizations entitled to participate by submitting written data, views, or arguments. Agencies are not legally required to air a debate over the proposed rules, though often they do. So under the rulemaking informal, those are the notice and the opportunities to comment. The notice with regard to place and time, opportunities to give your own views, data, or arguments to persuade the agency under the informal standard. Sometimes the agencies will be under a formal rulemaking standard, which will be the exact same as the informal standard, but when engaging in formal rulemaking, agencies must actually hold an adversary hearing. So there is going to be a hearing there where people can come and have a debate about the rule before it's promulgated by the administrative agency. When an enabling statute requires an agency to hold an adversary hearing in the rulemaking process, we just talked about that. Once you need to have that adversary hearing, it is going to be formal rulemaking. When a federal agency plans to modify or create a rule, it must comply with certain rules. However, the agency does not need to. And we just talked about the things they need to do there under formal, informal here. So think about those items when coming up with your answer for that question. Administrative burdens on business operations. There's burdens out there. Here we have 1977 total annual cost of federal paperwork amounted to $50 billion, in that the 10,000 largest business enterprises spent $10 billion annually on paperwork alone. The paperwork involved in licensing a singular nuclear power plant, the commission said, cost upward of $15 million. Excessive burdens of administrative. So talking about laissez-faire capitalism, that's bad. You need regulation, but we don't want to over-regulate. Congress enacted the Paperwork Reduction Act. It gives power to the Federal Office and Management and Business, OMB, we were talking about that before, in regards to fiscal and budgeting of administrative agencies, to develop uniform policies for coordinating, gathering, storage, transmission of reports, trying to get a reduction on this paperwork cost. What are some criticisms of agencies? Well, overregulation is going to be one. Also, that agencies can be captured by business interests or political interests. So in the thought process here is that large companies, let's just say Pepsi, for example, has some upper level management individuals, and they leave Pepsi but then go into a position at the Food and Drug Administration. Well, likely those people are going to maintain those ties with Pepsi, and then the more individuals like that go into the Food and Drug Administration, that agency can be captured or influenced by these outside forces, that outside corporations that are going to influence the Food and Drug Administration. Inspections. Administrative agencies can inspect. What's our limit there? All right, talking about some police searches there. Where certain types of businesses are closely regulated, surprise inspections are the normal and no warrant is required. For example, a business with a liquor license that might sell to minors are subject to both overt and covert inspections. Or a junkyard that specializes in automobile parts may be subject to surprise inspection with the rationale that junkyards are highly likely to be active in the resale of stolen autos or stolen auto parts. So if there's some reason why a business should be closely regulated, surprise inspections are allowed. No warrant is required. Otherwise, a warrant is going to be required, and surprise inspections are not going to be allowed. Another thought process in regards to inspections is if you're actually not needing to go inside some type of building to inspect, but can look at something as anyone else can freely look at the building, perhaps by just walking by or flying over in a helicopter, that type of thing that someone is allowed to do, taking overhead photography of something, that is not going to be infringing upon any type of constitutional right in regards to inspections. Here's an example about a Christmas tree farm where a person's growing marijuana in the back, where in order to get back there to see the marijuana, you would need some type of warrant. But if you used a drone or helicopter to fly over, just like any regular person, perhaps as long as it's not violating any type of law, can fly a drone in the air and you can take pictures down, just like Google Maps or anything like that, into a farm area. That's not infringing upon anyone's rights. Therefore, it's okay that the FDA could do that without a warrant. Freedom of Information Act. Under Freedom of Information Act, any person has a legally enforceable right of access to all government documents with 9 specific inspections, such as classified military intelligence, medical files, and trade secrets, etc. A federal agency is required under the Freedom of Information Act to respond to a document request within 10 days, but in practice it can often take longer than that to respond. Exceptions. Here are a number of exceptions. Records required by executive order of the president to be kept secret, interest of national defense. Definitely read through those various exceptions. Under the Freedom of Information Act, the cost of locating and copying records is paid for by the person requesting the records. The Freedom of Information Act applies to federal administrative agencies only. Regulated companies are required to submit confidential information to federal agencies to protect this information from disclosure in the Federal Information Act. Yeah, think about that one. Under the Freedom of Information Act, an individual can most likely obtain information regarding matters of national security. Yeah, we talked about that. Medical records of agencies' employees. Nope, that was an exception up there. And classified military intelligence. No, agency information that's neither confidential nor privileged. That would be the correct answer. Feel free to look through the exceptions and see what you think. Thank you all for listening in. I hope everyone has a great midterm. Thank you all for your hard work, and I hope you're learning a lot. Professor Crane signing off. Everyone have a good day, good evening, etc., wherever you are.